Okay, we are starting our IBB session. The last time that we met, we had a presentation from Jill about our specials teachers and their concerns. And we also had our special education coordinator with us. Or is she director? Director with us to answer questions about paperwork days and the 5 out of 7. And so today the agenda looks like we will start with our TA on late resignation and look at review and address some questions that NEA-Shawnee Mission had with it. And then we will do our TA on elementary PLC. We'll look at that and address any questions or concerns. Then we'll get an update on the work groups. The subcommittee on elementary specials teachers, the one regarding the leave days, and then we'll talk about the MOU regarding SPED paperwork days, and then talk about a couple of things that are sunset items, which is early resignation retirement payment, the personal day non-use, date on the Monday after the Super Bowl, and then some start framing and focusing some of NEA-Shawnee Mission's comp items, and talk about a little bit about longevity pay, the pay schedule, maybe going from monthly payments to bi-monthly payments, the instructional rate, kind of talking about that, and then talking about new hire payroll schedule and the date that they would receive their first paycheck. So we will just start with the TA on late resignation. Can you bring that up on the screen?
And while you're doing that, let me ask Amber, is the traveling teacher committee ready to report back here today?
Mm-hmm.
Okay.
Yes.
I want to make sure that was on my list. Do you have it?
Mm-hmm.
Okay.
Yes, that's.
Okay, so I will screen share.
Thank you.
So quiet.
That is really bright.
Okay, so I believe I sent everyone this. I did a totally new document just to make sure that we were starting from the clean and current P&A language, and rewrote the language to align with our discussion about making sure we are applying the correct statutory scheme to the employee's situation. And so the way that it reads now is that for anyone who's eligible for FML, they absolutely have that option as long as they provide an appropriate certification. It incorporates that sort of tweak that we talked about, which is what we really want them to do to meet with the spirit of this exemption is to at least have started and been gone for a month before they make that determination. So maybe mentally they take their 12 weeks and they're like, there's no way I'm coming back. I'm supporting a very, very ill spouse or something like that. But at least start it, see how it goes, and then submit your resignation if you feel like you're not going to be able to come back. Then this new language at the end states that, and this would be true for any employee, right? So every employee, regardless of how long you've been with the district or your FML eligibility, has the option of having that ADA interactive discussion. But if you are an employee, because you are in your first year with Shawnee Mission that is not eligible for FML, that would be your route to go if you have a medical issue. And we have a form that HR provides to employees where they would get their medical provider to explain sufficient information about what their medical issue is, what their limitations are based on that, and then suggested or possible accommodations. And then that process happens. And so the way that it reads is if we check that box and we go through that process and the employee and the employer, so the professional employee and Human Resources agrees mutually that there's just not reasonable accommodations that would allow them to work, then we would go to the mutual benefit exception. And so I know Amber had a question about, okay, so mutual benefit, is that absolutely necessary? And my explanation or response to that is that I don't think that it's feasible or practical, nor would it comply with the ADA for us to, for example, say upon a physician's note, you could auto be released from your contract. There's a couple reasons for that. One, because it doesn't give either party the benefit of that ADA interactive process. We're not checking that box. We're not going through that. And two, I would just be concerned that there's no check or balance to that. There's no way to have that discussion to learn about it. Now, I think as a practical matter, if you are coming forward with an ADA form that indicates a very serious medical condition where you can't, for example, leave your home, or you need ongoing inpatient treatment, or you're just, in some way or another completely shut down from operating, then I don't know how we get to reasonable accommodations, but at least we've checked that box. The other thing that I thought about in the car ride over is, we know because we looked at other school districts' late resignation provisions for comparison points when we initially started working on our provision, and they would just have this line that says medical. And so my thought in the car ride over was, well, how does that work? Well, as a practical matter in those districts, the employee isn't coming forward and saying, medical, I get to be released. It still has to be a mutual agreement. Ours just has more definition on it about how we would get there. We would use the ADA process as the way of getting there. So that's the explanation I have. I don't know if anyone has any further questions or concerns. I did also mention, as I was having thoughts about this in the email to Amber, that this is something that is a provision in our P&A, be subject to negotiation every year, just like it was this year. So if we try the shoe on and it doesn't fit right, or there's a problem or it needs to be adjusted, either party could raise it. And we have used, without sharing any identifying information about any employee, specific examples of where it didn't work. So I try and think about that when we have nerves about, signing something, that this is an agreement that's negotiated every single year. So some things may feel really permanent, but I think that, again, to the extent there's any issues, either party has the right to raise it. I told Amber I'm really hopeful that as we've slowly moved, that it is the right fit. I like our provision way better than any of the other school districts, because I think that it provides, on both sides of the equation, human resources and the employee, this very clear way that you late resign if you need to. But it could be potentially perfected even more at a later date.
So another one of my concerns is if it was a teacher in their first year and what if it was a family member that was ill and they did not feel like they could come back? So in this current way that it's worded, they would not be able to do that, correct?
They wouldn't. That's a great question, because really we expanded this when we wrote this to include those other qualifying reasons for FML. And if I remember right, we did that for a couple reasons. One, just, hey, if you're already out of your classroom for 12 weeks, that concern we had about continuity with students and education and impact on your coworkers is not really there as much, because you're already gone for 3 months. We're already having a long-term sub situation. But also because it was a way to be helpful and kind to employees who are in what would be a very terrible situation. So the mutual benefit exemption still exists, and that's where I think the professional employee and human resources would have that conversation, and where those sort of unique one-off things would go. And so that would have to be, because that would be very fact-specific. The ADA only covers the employee's own medical conditions, and so that would have to be a conversation about, as a practical matter, I cannot be here. And I am positive, and I'm sure Dr. Higgins can attest, that he's probably had those conversations or aware of those conversations with employees who sort of fall into that unique category of having a reason like that or something else similar. And I call that our catch-all, and that's where I would steer them.
As much as I appreciate those conversations, and I appreciate us talking about those conversations, my concern is without detailing that within language or within the TA, those conversations aren't required to happen. It's not required for that person to be able to go through those avenues.
So the concern would be that we would have an employee who has a practical impediment and HR would just decline to meet with them?
Correct. And again, right now, I know HR is doing a great job. Right now, I would be really hopeful. But that's not solidifying it in language.
Can you make it just a little larger?
Oh,
so
yeah.
we can see kind of how strong the language is in that area?
So, I mean, that specific concern, while totally a point of discussion, was not at all part of this original, I mean, this was all about employee medical things. So that would be, to me, a separate problem that we would need to solve is what about all these other things that aren't the employee's medical issues? Because this exemption was all for employee medical issues, and then we just sort of, agree that because it was FML certification, we weren't going to distinguish for those other reasons. And so to me, that would be an entirely new IBB problem of what is the mutual benefit exemption. Like, I'm just trying to analyze that. You know what I'm saying? Like, that would be a new IBB problem to solve is how do we know when we fall into that catch-all mutual benefit bucket?
I agree. However, if we're making that same exemption for an employee who does qualify for FML, and again, I'm just going to use the example of an ill spouse. Mm-hmm. I'm just concerned that we don't have a way as strong in language under the ADA provision as well. And I just see a little bit of inequity there just based on years of experience with the teacher. Or not experience with the teacher, but years in the district. There's just a little bit of an inequity piece that I'm not comfortable with.
And to be direct, that inequity exists in the law, right? Like, that's not the district's framework. The idea behind the FMLA is that it is job protected. This is sort of like a weird lens, right? Because the whole point of FML is your employer is directed by the law to hold a job for you. And we're sort of talking about on the other side where the district's like, no, you signed a contract, you need to honor your contract. So it's sort of this weird push and pull because the FML is really, employer, you are directed to hold this job for this person and allow them a break to take care of their personal or family needs.
And to be clear, you're sort of using those standards around FML to release them from their obligation to work for the district.
Yeah, which is, again, really weird and why we've sort of had this, I want to steer employees to the right legal framework when they have a medical issue, right? And I think it makes sense to use that for our late resignation medical exemption. But those provisions are the opposite of leaving your job. Those provisions are, we're going to hold your job for you, or we're going to provide you job accommodations to empower you to work. Because these come from a more antiquated time when an employer might, right? So like 1970s, oh, you broke your arm, you're fired, right? And so they mean to protect the employee against that.
So are you thinking, when you talk about inequity, just for some clarity for the group, are you talking about a newer teacher doesn't have the same opportunity to late resign as a teacher that's been here longer?
Correct. And again, just kind of this is a hypothetical, just let's say you have two teachers that for some reason, two ill spouses, same exact time. One teacher would be able to resign under FML if they had been with the district
If they got the time.
for over a year. But then if one of those teachers had that spouse that was ill, under the ADA, they would not be allowed to resign.
But then under
Correct.
mutual benefit, they may be, but you're saying the mutual benefit is not worded in here as a guarantee?
Right,
Well,
like
we're-
the maybe is what I'm, like how you,
Well,
I know that's not
I
how
would
I
like
have it
to-
phrased up
That's why I'm
here.
trying, that's why I wanted to make it larger, because this is a matter of now, what does it say, right?
Right.
So when it says, professional employee may resign pursuant to a mutually agreed separation agreement under mutual benefit exemption, where is CIII?
So I can bring up that provision. And-
Yeah, that would be helpful for
Right,
me.
you gotta
And
see what's in the contract.
So
before
the
you say
idea
something.
behind FML, let me circle back to where I started to see if this makes sense. You have to have worked for your employer. This is the theory behind it. This is not Rachel. This is the theory behind it. You have to have worked for your employer for a certain amount of time before that employer is required to give you job protected leave. So it's like you earn that. And that's so that you don't start a job and 2 weeks later, suddenly you're, oh, well, I have this situation, I can't be here, job protected leave. The law says, employer, you can let them go. Or you need to go through ADA. ADA, they get day one on the job, but ADA doesn't give you necessarily 12 weeks of job protected leave. So, that's the idea behind it is, if you're that first year teacher, and again, I'm not saying Shawnee should whatever do this. If you're that first year teacher, the idea is, I'm so sorry, you haven't been here long enough to earn that 12 weeks of job protected, still have health insurance available to you, leave, but you may resign. The law doesn't want you to have to resign if you've earned that job protected leave by being there for at least a year. So it's like sort of this odd, we're using it as a path to resignation when those laws aren't exactly for that. They're to get you back to work. But again, I think it's better because again, instead of relying on this conversation between HR, we're saying use those processes. And if you use those processes and they're not working, then we move to resignation because we check those legal boxes first. Let's see here.
It's on page 7.
That was awesome.
Page 7 of the document.
Oh, okay.
Oh, yes.
Oh, yeah.
Okay, so all it says is, we may agree to release an employee.
Where are you at on that? Under, oh, okay, got it.
So here's-
We actually read it, the assistant superintendent or human resources may agree in writing to release, okay. So you're saying what?
I'm just,
I can clarify a little
Yes,
bit.
thank you,
So
Amber.
for me, currently it says, if a person takes FML, then they may provide a minimum of 21 calendar days advance written notice to resign. Whereas if they have ADA, it has to be mutually agreed that they can leave the contract. Whereas someone else that's taking FML can give 21 days and be out of their
So
contract.
there's three things, FML, ADA, and mutually agreed?
Yes.
Okay, so are you talking about the ADA piece of it?
Well, if they're
Or the
first,
mutually agreed
I'm
piece.
talking about currently, there is no way, if you are a first-year teacher and you feel like you're struggling in your classroom, to leave your job without the district agreeing that you can leave.
So what would you say to that? Shall?
I wish we could have something where it said they could give 21 days' notice as well.
Then we could test that against the interest.
Yes, that's
Right,
what,
I'm going to pull you back to these interests here in just a minute to determine where you go with this.
yes. Because we used to have lots of different provisions in place where a person, if they felt like they could not perform their job, no matter how many years they were teaching, could leave. I do not think it is in the best interest of children, staff, anybody to have to continue to work a job that you do not feel like you can do because you're feeling so overwhelmed and so stressed. And I feel like people have asked for help from administrators and they still feel so overwhelmed with things that are going on. And I don't want them to have to continue to be in a building when they feel like they cannot do that.
And then what would you recommend would be some sort of guard for not just saying, hey, anyone can resign with 21 days? Because what's the point of a contract?
I'm saying if they feel like they cannot do their job
Okay.
because of what is going on. Like,
Right, so then what?
And it's not so much the physical part, I think it's more like the
I got it.
social emotional piece. Like if you
Right.
really feel like you literally cannot walk in a
And if you
building.
had FMLA, you could, that's
That would be fine, but like if
And
you're-
ADA perhaps, and then
Right.
if not, the district's still saying, but we'll still meet and see if we can agree. So then, is your concern ADA and the mutual benefit one?
My
Or just
concern is not the
mutually
ADA part.
Okay,
Mine is
because you
the
said ADA, that's what I'm trying to get.
mutually agreeing, because
Okay,
they
under
have
mutual
to
agreement,
mutually
right.
agree that they're going to let you out.
Okay, got it.
Whereas the other
I
one.
think you said ADA, and that's what I'm trying to clarify.
I just meant,
The mutual agreement's under the ADA.
yes, so that.
Because-
But I
because-
think of them as three separate things. You're either going to get out with FMLA, you're going to get out with ADA, or
You can't get out with
get
ADA,
out of
right?
agreement.
So,
But I
again, we're
thought the
talking about,
the examples were about the spouses, so I feel like we're kind of talking in
That was
circles
his.
here.
Mine is about being able to get out if you physically feel like you cannot, like social emotionally, you do
Right,
not
so
feel
I
like
mean,
you can go
that's what I'm
into it.
saying, we got to sort of break it down to what, like, you're raising the issue of, I just want to make sure a mutually agreeable benefit consideration happens if two people have a sick spouse, right? Which is probably a different fix, or we address it differently than what you're saying is, there's no accommodation here for sort of mental health if you don't have FMLA or ADA. So I think we're getting confused because we're not sort of taking one at a time.
And mine was more a hypothetical that just kind of came out. I agree with Amber, that's my main concern, and I just kind of went with my hypothetical farther than I should have. So my concern is that same as Amber's.
Is the mental health issue.
Correct.
Okay, not necessarily the guarantee that they'll have a meeting, but you said that, you said that right now they're meeting with folks, but we can't guarantee that they'll continue to have these meetings to consider their leave.
That or an avenue to resign without penalty.
Yes.
Got it. All right, let's go ahead and share interest real quick, and then let's revisit how we might be able to address solutions with this, okay? But is everybody clear on the order that folks can go to try to get out of their contract? Because what we're doing is we're trying to figure out how to let people out of their contract. And you guys said if it's a medical issue, we don't want to be, I think the district said, we don't want to be responsible for making medical judgments. Can we just use the FMLA qualifications for medical?
right.
Right? If you're sick enough to take time off, then perhaps we're going to agree that you're sick enough to leave your job. And if you don't have FMLA because you haven't been here and worked 1,100 hours or however many it is, then let's look at ADA. Can we accommodate you through that? Okay, FMLA could include yourself or your spouse or a family member. ADA would only be yourself, right? And so under ADA, they may be able to leave for their self. And then if it was a spouse situation, or if it's their self but no FMLA and no ADA, then it go to special circumstance. Meet and discuss as their, right? So you're saying that special circumstance you want to try to, would the solution then be, and I don't know, but I'm trying to get to where your concern lies, you want to give examples of what a special situation might be, and you want to make sure it includes mental, and you want to make the district must do it versus may do it?
So we did
I mean, let's
full-
wait, when I ask a question, I want to wait for the answer, if you don't mind, Rachel.
No.
For me, it's that I don't think it should have to be a mutual benefit, because and I know that the district wants to keep people in their jobs, but sometimes you literally physically do not feel like you can go into a building and work.
And if that's the case, I would think there is a mutual benefit to the district, same as
But
the
they
teacher
don't
just
have to
said.
say yes to that. They do not have to release you.
Okay, so that's what I'm
And
trying to get
that's
to.
what
So
I'm
are
trying to
you, is the operative word that's the problem here is the may?
say. May.
Okay, not necessarily what the examples are. So if you were to change it to must let them go with 21 days notice, do they even need to have a meeting? Because why do you need a meeting? Because you don't really even need to tell why you're leaving.
I would feel more comfortable if they could give 21 days notice.
With no terms around what it could be for.
I do feel like they have to get a note from their doctor. I do feel like they do have to do that. They just can't just be released for nothing. Like, there has to be proof or evidence from a medical professional saying that they cannot come into the building, they cannot continue to work. But I do not think that the district should hold the person to have to do something when they feel like,
Would
With
that
a
person not be
doctor's
able to
note.
leave under ADA?
They would.
They would leave under ADA. There are 3 different ways to leave, and I think you guys are collapsing the ADA and the special circumstance.
they could leave under the ADA?
Yeah.
You're saying they can leave under the ADA?
So they would need to go through, in this, and I hate talking about hypotheticals.
Because I do
but-
feel like people are starting from a different understanding of what is up here.
So their physician, I mean, I don't think it's tenable to have a process to have a physician's note to get out of a contract. That's not something that's sustainable for all those interests that we outlined, and we sort of went through that whole discussion about, well, what standards could we have? So if you are a person who's, let's say that the source of your mental health impairment is your job. So you would go to your medical provider. The ADA paperwork is pretty extensive. It's 2 pages, right? And the physician would write on there what was appropriate, right? And if it's going to have panic attacks upon entry to her workplace or his workplace, right? If it's those sorts of things, and we sit down and have this discussion and say, well, what if your coworker met you at the door? What if we had someone sitting, we like did all sorts of reasonable things. We try it for a day, it doesn't work. Then obviously we're at a place where
There is a mutual benefit.
we haven't agreed on
There is a mutual
reasonable
benefit.
accommodations. But it's really legally risky not to have gone through and tried that. And I'm telling you this as a protector of the school district. I would not want to create a situation where doctor's note, get out of contract, circle back around, make an ADA claim against the district. You didn't accommodate me. Constructive discharge, had to leave. I was so stressed out. We eliminate that by at least having walked through that process. We received your medical paperwork. We have records where we offered you A, B, C, D. We even tried A, it didn't work, okay, now we know. And now we go through the separation agreement, you release ADA claims.
And so FMLA for the purposes of missing your job, missing days, time, hours on your job, I think you can take it in 15-minute increments even, up to 12 weeks, and anything in between. That is for you to miss time, and you still perform your job as expected to every day, no accommodation, other than I need to be away for a while, right? But the ADA really isn't about even being away or missing work. The ADA is about the employer has to grant you conditions that you can work under, which is really different. And so if you're saying if someone turns in a doctor's note that says they're having issues and you don't try to accommodate them, there's a liability where they can say, my doctor gave you this and you offered me nothing.
I think it creates a lot of risk, and I think also, I think the right thing to do by somebody, particularly in their first year and struggling, is to have at least tried and had that conversation, right? I mean, you've gone to school for how many years to get this degree? You've done your student teaching. We are literally talking about first year teachers. I would hope that what we do is try and have that conversation with their rep present, right? And like, see if we can keep you so that maybe you continue on and maybe next year you do a different grade level or something, right? But I feel better before we just say bye-bye teaching career, that we've at least gone through that ADA process. What it's going to depend on is what that ADA form says.
Yeah.
That's what it's going to depend on, is what that form says. And if it really is, my patient cannot be in a school building, those sorts of things, and we can't come to something, then I think we're there.
Under the ADA section.
Yes.
They wouldn't have to move and then look for a special circumstance. But if FMLA doesn't work, if the ADA paperwork doesn't really support that they can't work, then you'd go to the special circumstance meeting. So are we wanting to drill down on that?
So I'm okay if you do work through the ADA. I'm not saying that. I do want you to try that. But I'm like, after we've tried that, if someone feels like they still cannot come back, would you allow them to leave their contract, is what I'm saying. I'm saying do all the things, but like once we've done all that, I want them to be able to,
Richard, you're gonna have to quit screen
if we've
sharing when we
tried,
bring interest up.
Sure.
they've tried everything.
So here's where and I'm just kind of, hang on, let me get off of this. Am I off? Yes, I think that's you. I'm going back to our circle back conversation. One thing we talked about is human resources administrators don't want to question medical issues. They aren't going to question what your doctor has put on an ADA form unless it's totally inconsistent with, like, there's a reason to suspect it, right? Like, this is a psychic, not a doctor. We, see you skipping into the building every day. Like, I mean, we would have to have some counter evidence. So there's not going to be this questioning of, I'm going to substitute my judgment for medical professionals' judgment. So that's the first point I want to make, is what this is dependent on is the paperwork. And then here's the conflict that we're at, and this is back to our philosophical discussion that I think we've had a couple times in the past year about employment contracts, right? Like, we all operate in this world where every single person at this table has a contract that they sign, and there is a positive to it and there is a negative. And the positive is employment protection, which is incredibly strong for people in the education world. The negative is you've signed on the dotted line for 180 something days. And again, I think just being adults and talking about this, and what I've seen in Shawnee Mission is we know we're not gonna like force someone who legitimately cannot work to work. That is not good for either side. But there are also cases where someone is just not honoring their contract, right? And they're not to that point where we're in a unable to do reasonable accommodations, unable to get you to the actual resignation date for next school year. And so I totally understand the need to balance those things, but we also have to have, balance in the contract between someone honoring it and then the district having to honor it on the other side as well. And I haven't thought of a better way to do that, but I would be concerned about meeting our interests if 3 weeks notice you could get out of your contract.
John, I sent you the 5-step issue statement in an email, so I'm assuming that means you took notes on that. It was in February. Well, it's challenging because I sent you an email that had the issue statement written, Shawnee Mission School District issue number 2, how do we reduce negative impact on late resignations for all stakeholders? And then 1 through 5 is blank, and I just emailed you the blank doc. So I'm guessing that I wasn't going to be here. Just search for from Stephanie Haynes with attachment. And I'll tell you the date was, I think, February 21st. And then I have a separate document that's from a couple years ago. The problem statement was, how do we ensure highly qualified teachers in the classroom throughout the year? And that focus was on late resignation. So I can share that, but there is another one you guys worked.
I think we have what was on the issue statement, but I do not have an email.
I wonder if you just took notes in the body of the issue statement, which sometimes that's kind of how you prefer to do it. Does it look like their interest identified?
Yeah, I do have that.
Do you want to just read out what the interests were there?
We only have interests that were already in the boxes pre-filled.
And what does that say?
Avoid the detrimental impact on students caused by late resignations, avoid inconsistency in the classroom and disruption to instruction, avoid the burden and stress that late resignations and unfilled positions place on our teachers or building leaders and on district administration and HR, avoid the undue burden on our substitute pool, have qualified teachers in all classroom, allow HR to secure a suitable replacement for a professional employee before they are released from their contract, except in the case of exemptions agreed to by the IBB team, deter teachers from breaking their contract and leaving their positions before a suitable replacement can be secured, prevent abuse of any exemption of the late resignation provision. And then we had our current process, which is liquidated damages over the summer, $500 in June, $1,500 in July, $2,000 in August before the first contract day, and suitable replacement. Exemptions are moved with the spouse, job promotion, mutual separation agreement, FMLA.
Okay. And then you all drafted that. And now, I don't know if you can screen share them, but your question is this. I'm going to guide you back to the IBB process, because that's where you guys make the right decisions, just the right thing to do, not a positional decision, right? What's the right thing to do to meet most of our interests without harming others, right? And to solve the issue statement. So what you've done so far is you've now, based on those solutions, you've now given FMLA to folks that that don't qualify. You've then, if they don't qualify under FMLA, you've directed them to ADA, so there's another chance for them to have a look at leaving. And then you've created this mutual benefit thing that y'all talked about, and now Rachel's put in writing that, hey, we can just meet with them like we do now, and if they've really got to go, we let them go. So those are the things you decided to do to meet those interests, okay, without harming them, ideally. So now, if we talk about doing a change to what you already decided to do, because you guys aren't in the brainstorming session anymore, you're proofing what you've already decided to do, right? You're proofing what you've already decided to do in a previous meeting. So now, if we want to go back and brainstorm more, then I want you to keep your focus on those are the interests you said you wanted to solve and try not to harm any. So, and it sounds like you're saying, what I'm hearing, and the reason I'm getting a little maybe passionate about it is because I'm trying to sort through them so that we objectively look at the issues, sort through the concerns that this doesn't work anymore, right? When you all brainstormed what's going to work to do this, this was it. And now if it doesn't anymore, I want to get, remember we said if you're in disagreement, we got to get to the crux of where's the disagreement. Either what interest does it not meet? How does it not solve the problem or not meet an interest? Or what interest is it harming? So I would say, if we can think about how does this not meet your interest, or what interest is it harming, and in what way, and that'll help us drill in on how we can adjust it, or edit it, or do something to address that. What interest is it not meeting, or what is it harming? And then let's drill down on how do we solve that. But I'll read the interest here, because you guys did two different issue statements on this in different years. The one you just read, and the one that I have in front of me, which is more how do we ensure highly qualified teachers in the classroom. Yours was how do we reduce the negative impact, right? Which are highly related, but this is how you solve both. So I'm going to go ahead and read my interest, not mine, but the ones you all had before. I know this is tiny, and I'm not sure what year you did this. I think it was maybe just last year. One you did last year, one you did this year, or both you did last year and then you relooked this year. Jill, do you remember?
We originally changed it 2 years ago.
Okay.
Third year.
All right, so
I believe that the FMLA provision was put into play last year,
Sorry, I thought you meant how.
correct? And then, so this year, there's conversation about altering the language within that FMLA provision.
but
That-
was the ADA and the special circumstances put in there last year or this year?
This year.
Right, okay,
So
got it.
cleaning up the language, the FMLA portion of it is where the ADA and mutual benefit have come into play.
Okay, so here's the interest that I have, guys. You wanted to retain the teachers that we recruit because they're the best, that you guys are hiring the best. Ensure the best educator possible for all students to get the best outcomes. Fairness and honoring the contract for both parties, honoring the contract they entered into. Obligations to families for the best teachers, family commitment. Reputation of quality teachers in the district. And respect that there will be situations, unexpected situations or opportunities that are unpreventable. So that list of interest and John's list of interest are what you're trying to say, did this solution do that? And if it didn't, let's hone in on where it didn't and then be specific about where we might want to fix or what interest we may be harming. I think I'm hearing Amber say, if I could speak for you, you're saying that are we going to not have the best teachers in the classroom if we don't give people an out? And I think that if you don't figure out how to balance that with an open carte blanche, just go, give us 21 days notice, then you're going to harm all other dozen interests, right? Leaving, just the disruption, the ones John read.
Correct.
Right? And there's a push-pull here a little bit, right? So it feels like, it sounds as though you're saying maybe no guardrails. These are guardrails you guys previously agreed to. Is there something in between? Is there something in between? And the effort you make to find something in between, you're going to have to really work hard on, because I first thought is, well, could you give the mutually beneficial reasons by way of example? But then are you going to box yourself into not being able to know if it doesn't fit in an example?
Yes.
Did you just screw yourself?
Yes.
Excuse my language. Right? But if you say the district must let them go, then you certainly have harmed all the interests John read. So that's where I want you to start thinking creatively as a team together instead of going down sort of positional, trying to convince each other. So is there a way to find that middle ground here? And did you have something you wanted to jump in on?
I just also want to say, like, the fairness and honoring the contract for both parties. When it's like mutually agreed upon, you might decide you're going to let one person go, but you're not going to let another person go. And that is my concern. because I do think that that can and probably has happened in the past where we're going to let one person go. Same situation for somebody else, we're not going to let that person go. And I've seen that happen. So that, I feel like that's my concern. Having the best teacher in the classroom is my concern because I have also seen that happen.
Right.
So those are my two concerns.
So can I say that there are two more interests that have come
Well,
up
I
that
mean,
weren't on our previous list? And I heard one from you saying, and I heard you say it, equity in this process? Like, how do we ensure some equity in this process? So that sounds like an interest. And you were talking equity between teachers, but you were talking equity between years of time here.
Yeah.
Okay, and then I heard another interest that wasn't on the list, and that was liability. Do it in a way that we're not going to get sued, as we're trying to do good by teachers. Don't open the district for lawsuits, which would certainly harm interests that are already listed here, and it's an interest of its own. So I would add those to the list of interest, the way we have to address this. It makes it harder. What other thoughts are people having? Yeah.
The preventing abuse of exceptions is real. So I will say it's difficult in situations like this, or in personnel situations, to say two situations that are exactly alike, because there are no two situations that are exactly alike. I think that needs to be stated as well.
Is it something that, I'm going to brainstorm ideas here just to get you guys in that mode, okay? And maybe someone else can open a Word doc with brainstorm ideas, and I think the focus is how do we ensure, more equity in the application of those circumstances, but
The language in the contract last year wasn't equitable though either. Just to be frankly honest.
No, you guys continue to move forward.
The FMLA provision says 21 days. The other provision, if you didn't qualify, does not say anything about 21 days. So it was inequitable. I think we need to go back to what's the right thing to do? What's the best thing to do?
Yeah, but I mean, we never say it's not a legit interest if it's brought forward as an interest. Equity being an interest, we can't dismiss that it is an interest,
Sure,
right?
sure.
Same with liability, whether it was there before or not. But so, one idea may be, could there be some language? And again, I think it's hard to monitor language like this because you may think the situations are identical, but in some way they're not going to be. But is there some kind of language that can say, that the district will, make all efforts, will strive, will approach each case with even-handedness? Or is there some language that you can do that really highlights that you all want to recognize and ensure some equity? Maybe some language related to that. But I'm not sure where you guys go with this idea that if they aren't able to leave under FMLA and they aren't able to leave under ADA, when it gets to a mutually beneficial leave agreement, how do you still have perimeters but not, right? I'm not sure where you guys go with that.
It's challenging, and historically, it was very subjective. I mean, we got to this provision to try and remove the subjectivity that the HR admins were forced to have, frankly. And so that's why we looked for those processes and used them as the backbone. Because I absolutely agree with Amber. Equal treatment is very important. I have not thought of a better way to do it than using the FML certification or the ADA certification. Again, with we're not going to substitute our judgment for physician's judgment, right? So if that form indicates very extreme issues of the kind that you were saying, and we treat mental health the same as we do physical health, and the law treats it the same, is going to be dependent on what that form says. The line is, a physician cannot write on an ADA form.
When you say form, you're really talking about the ADA form.
The ADA form. A
Because
physician
FMLA is going to work.
cannot direct an employer. So they can't say employer must release employee from the contract. What they need to say is, this is a medical issue, these are the limitations. If we're talking about accommodations, they can work 1 day a week. They can work 2 mornings a month. Those are not things we can accommodate reasonably.
so you
So
would
that's
measure
where
them.
we would end up.
And then they would leave on under ADA.
So
They wouldn't leave under ADA, they'd
They would
leave
leave.
under a separation
Yeah.
agreement.
Yeah, that's important clarification again.
Okay, gotcha,
because I
gotcha,
keep
gotcha.
saying
'Cause you're not
ADA
accommodating
does
under
not-
ADA.
ADA is
Because ADA
the
is not used for
accommodations
people leaving,
process,
it's
and
used
if they
for- yeah.
can't, we can't accommodate, then it's
Yeah.
the mutual agreement,
So-
mutual separation.
If an employee has had their ADA meeting and they don't agree with the accommodations provided, that they don't think those are reasonable accommodations provided by the district, what are their avenues?
So reasonableness is actually an argument the employer makes. Like, we cannot buy you a $5,000 piece of equipment. Right?
of course.
So it's actually, again, because we're talking about flipping this on its head, in this scenario, the employee wants the accommodations, right? Like, they're like, I want these things. And the employer's like, well, I'm sorry, I can't, do something that would be extremely costly or really burdensome or change our educational programs in some respect. But let's say we're at that point where what you're talking about is, I'm sorry, as the employee, I've talked through all these options. I don't feel like any are going to enable me to work. Again, if that's the point that you're at and you're the HR administrator sitting on the other side and you've offered all of them and the medical documentation supports that, it doesn't say like, just needs crutches to get between classrooms or something like that, then that's where we are, right? And I would think if we are in a scenario where we have an extreme ADA form and the HR administrator saying, sorry, like lay down in a bed in the front of the classroom and teach, that their NEA rep would come in and advocate for them and we'd be negotiating a
And I would
separation
argue
agreement.
that also would create liability for them,
Oh, yes, I think it would.
right?
Right.
Depending on what happens in that classroom.
So it's going to be dependent on what that paperwork says.
Right.
It can't directly say employer must release employee from contract. That's not the physician's judgment.
No, of course not.
But it can say, these are the real issues and we aren't going, the district's not going to substitute their judgment for
I see
that.
what you're saying, okay.
So if I were advising a teacher who's going through that process, I would say, you need to make sure your physician is very clear about all of your physical limitations or other limitations and why. Right? Like that's where the counseling would go.
I'm going to go ahead and quit screen sharing, but if we need to revisit these, you've got your set of ones and I've got this set, which I think they kind of come from different angles, but they address the same issue. But
I love the picture.
I usually screen share. Well, thank you. I'm usually screen sharing a document. You don't see my screen. Where do you guys want to go with this? Regardless, this is going to require some member education. Any way you go with this, it's going to require members knowing their rights.
My big thing is just making, like, if we go forward with what the verbiage that's already there, just making sure the admin are aware of all ADA stuff, making sure that there's a way to, I guess, document that said accommodations are happening, obviously, and just ensuring that we're going through it in a fair and appropriate way. That's my big thing with all of this, is because I feel like it could kind of be subjective to an extent, and that would be an issue.
Subjective when you get down to that mutually agreeable.
Yeah.
Yeah, got it. What about the idea of showing the commitment that the parties have to, objective application of this process? Is there a sentence that does that? So that it's really about accountability, self-accountability and accountability to each other. And for a teacher to read the contract or an administrator to read it and know, oh, I have to be equitable with this. I mean, that's the only reason I'm saying is an idea to put something in the contract. So it's not just assumed people will be equitable if we say they will. I don't know if there are thoughts on that as one idea. And by the way, there could be many other ideas.
My thought is maybe we could add a liquidated damage for just that part, so that if they did feel like they were not able to reach a mutual agreement, that they could get out that way.
I'm going to go ahead and pull up a Word doc for ideas, guys.
Because
Because I feel like in the past, when we had a liquidated damage, that is the most subjective way, because you pay the money or you don't pay the money. Nobody gets to make that decision. It's,
Objective way.
Objective, yeah.
Yes, thank you, thank you.
I was like, wait,
Are there no
wait a
liquidated-
second.
Sorry, thank you.
You're fine.
No.
During the
I get
school year,
very-
there are no liquidated damages.
No longer. We
Yeah,
had
right
it
now it's
2
if
years
they
ago. Yeah.
resign during a certain frame, whatever.
Correct.
Okay,
Over the
also, did you ever and do you still don't take report on their license?
No,
Was that-
we do.
Okay, because I see that now.
And again, so our discussion of that was, if you have liquidated damages, that's your remedy. And I shared again as people who administer this policy, that is not a feel-good. Like, demanding money from people when they're in a situation where they're saying they cannot work and then sending collections after them, I am just very, like, just from like a moral perspective, I don't like that. When you go after their license, you have a neutral decision maker, which is the PPC, which looks at the facts and makes the decision of whether it is appropriate for them to have a sanction against their teaching license or not. And that, to me, serves the teaching profession and the school districts equally. So they get to make their case. And so if it was, hey, I tried to do this ADA thing, they ignored my, we couldn't get there and I was forced to resign, let's let the PPC decide if they need a license or not, rather than us being like, give us $3,000. Like,
So I have a question, and it's okay if we pass this, and that's fine, it's all good. If someone files paperwork for FML or ADA at that point, like with HR, can HR say that whatever is on that paper is not serious enough to then go on that leave?
That's a really good question. And that's a law school legal question because
That it is. and I have not done that, so.
there are different definitions. FML uses this phrase, serious medical condition.
Okay.
And so when you start working in HR, which you guys may do someday, that definition is a little bit higher than the ADA definition, which is just anything that prohibits you from engaging in a normal life activity like walking or breathing or eating or standing or anything like that.
Okay.
So serious medical condition is not like temporary illnesses.
Right.
If you have a cast on your arm, you can't use FML.
Right.
The ADA, if you go to a law conference on the ADA, they will say everything is an ADA qualifying disability but a paper cut.
Okay.
That's pretty much what they say. The ADA scoops up this very much larger realm of things that trigger an employer's responsibility to have that interactive discussion. So for FML, if you wrote on there, I've had the sniffles, I have an air boot on, those kinds of things, we might as the employer go back and be talking about the definition of a serious medical condition.
Okay. So the employer gets to decide whether or not something's a serious medical condition under FML though, even though a doctor has submitted that paperwork.
So the doctor doesn't say it's a serious medical condition, the
Just
doctor
gives
defines
diagnosis
the
and
condition.
prognosis.
Sorry, I don't, the only
doctor
reason I used
would-
FML is for pregnancy, so I'm asking.
The doctor would just define it. So they would say,
The doctor would
they've got
define the medical
bronchitis.
condition and then,
And usually prognosis, like what their regimen of treatment or what they
Yeah.
expect to.
and then HR would decide whether or not that would be.
Whether that
Correct.
meets it, and what that means is they would ask me for legal advice, and I would go do a bunch of research and figure
Right.
it out. I can tell you that I don't think that has ever happened the entire time I've been here. Back in my initial days of representing school districts, I did look at a couple really funky certifications, mostly for potential fraud. It didn't look like a doctor had completed it. I literally worked on situations where employees wrote their own form and hadn't actually seen a doctor. I've never had to do that in my time at Shawnee Mission. It's usually like a gut check. Somebody gets a form and they're like, this doesn't look right. And then you're questioning it. Usually it just results in you going back to that employee and saying, try again. This is not sufficient. This is why. Try again.
Okay. Thank you.
Yeah. And I don't think we've ever either, I can't think of a time in Shawnee Mission where we've said, oh no, based on what you're saying, your disability is, we're not required to have an interactive conversation with you. Because it really does scoop up a lot, and I think we're nice in Shawnee Mission. If someone needs help, we're just gonna help
We have
them.
lots of conversations.
What other ideas? I captured ideas that just sort of come up in the process of me seeking clarity, right? So we could do language in the contract demonstrating a commitment to applying the process and/or the approvals under a mutually beneficial agreement equitably or objectively, or both. And then you said something about just go back to liquidated damages, which is maybe expand liquidated damages beyond the time frame it is now, which would be kind of going back to what you had. Change may to shall under the mutually beneficial section. Include examples of what needs to be mutually agreeable situation to include mental distress. But the question is there, do you want them to try to go through ADA first and then make it something that you say, you know, it's an example that should be approved? That's just something that, remember we said this is how it could address what was coming up, so I'm going to put it up here. What other ideas do y'all have?
So I'm not sure I like this idea,
Let's throw it
but
out.
I'm going to say it.
Get us rolling.
So I know, Rachel, one of the things that you want to ensure is that there's no liability concerns on the district. And part of that is making sure that you're meeting, if somebody wants to resign under the ADA, that you've provided those accommodations or had the employees had the opportunity to take those accommodations. So saying that the employee will have a meeting with HR, an ADA meeting with HR, and then if either side feels that the accommodations are not reasonable or cannot be presented, then the employee will have the opportunity to resign with either liquidated damages or X amount of days notice. So then they're still meeting with HR, you've provided them with the potential accommodations needed, and then they still, so they had that opportunity to say, hey, we're going to work with you with these accommodations. We're going to provide XYZ for you. And then the employee could say, well, I want XYZ too. So that gives the district an out too. And then if either side is like, no, that's not happening, then there's either liquidated damages or X amount of days notice. That still means the employee can't just get up and leave. There's still something there. But they still have an opportunity for resignation. I hope that was clear.
Is that, is that sort of a version of expand liquidated damages time frame? Because, or not, right? You're going to have to expand the time frame for this circumstance. Like, are you saying language that says a meeting will happen, and if either side doesn't think the accommodations have worked, or, and fix me if I'm wrong, I just tried to type while you talked, the employee may resign with X amount of days notice or liquidated damages.
Correct.
So then there may be another chart for liquidated damages or expand.
I don't know if we'd need to go that detailed into it. I mean, I would say for simplicity purposes, one or the other. I don't know which. I think obviously that's a thing for the team to decide.
Point of clarification.
Yeah.
So essentially what the suggestion is striking the words mutual benefit exemption out
Correct.
and adding in a number of days or liquidated damages.
Right.
So
After the ADA meeting has happened.
correct. So, and just to be clear, the mutual benefit, the mutual separation agreement, like that could be a resignation tomorrow. There is no statutory, you have to wait for 21 days.
Right.
And there's no money typically attached, there's no liquidated damages as well. So is it just the language separation agreement that is causing us pause? Because that seems more detrimental and harmful that we're saying,
I see what you're saying.
using a separation agreement, like that employee could resign tomorrow with a separation agreement, but now we would say, no, we're going to make them wait X number of days or pay liquidated damages.
This is hard.
That was what I was trying to get at earlier, is like if they come with a note and we're honoring the ADA process where that position's indicating extremely high level of limitations and extremely, needy accommodations, or the physician might not even have any idea. Like, they don't, they may say, I don't have any idea. Good luck, employer and employee. then, yeah, then we.
Then we have the conversation, we try to come up with accommodations. And if there's accommodations we come up with that we both feel comfortable with, we put them in play and see what happens. And if we don't, then we look at the separation agreement, which could be in
So that's
play
really,
immediately.
so right, so that's really the difference between mutually agreeable and what you're saying is, one doesn't identify how many days' notice if it's mutually agreeable, that, and it doesn't put liquidated damages. But what you're saying is really what is happening in here. What in here meaning in the language that was put on the screen. This doesn't say, but you did say either side. I was intrigued by that. So it didn't have to be, that's maybe the crux of the difference here, right? Either side could say it doesn't have to be.
Because how it's worded, my concern, to wrap up this whole conversation we're having, my concern is mutually agreed upon. And if there is a disagreement on that mutually agreed upon, say the employee's like, I cannot work, and the district's like, no, you can.
So I'm going to flip it the other way. What if the employee says, I can work, and the district says, no, you can't?
And that's where I'm going. Yeah, no, I see what you're saying.
Right?
And then that's where I came up with the phrase either side on this.
So I got a question. If the teacher did participate under the current language that you guys are looking at in a meeting, and the district said, we don't think it's reason to let you out of your contract. And if the teacher really wanted another contract, they would just get leave, right?
They would just leave, and
And
then-
right now, as it stands, what would the repercussions for that be?
If they were to just leave,
If they said, yeah, if they
we
were.
would terminate them.
Okay, and then the repercussions would be?
Potentially, I would have to file, which is, I never want to do this, and I hate doing this. I have to file a complaint seeking their license.
Okay, so
And
then
I
the-
just turn that over to the PPC. I don't argue it, I don't do anything, I say,
Okay.
PPC, you decide.
Okay, and is
Here's
there
the
another
facts."
repercussion besides that?
They have to mark on their contract for,
Yeah.
or on their
That they
future
were
job
terminated.
applications that they've been terminated.
So would this also then need to reference that that shall not happen if you're looking to protect people?
Clarify that for me, I'm sorry.
Like if an employee says, I don't agree. In other words, if you guys go with this solution where if the district doesn't think they need to be out of their contract after all of this, but they still want to go, and you're saying, okay, then go ahead and let them resign, but have them pay liquidated damages, and maybe we set up days' notice, would that still happen? Would you want that to still happen? Termination on their, I mean, I don't know, what do you
I
do with
think
that
there
then?
should be that avenue. I don't want to say I want it to happen,
No,
but.
it's going to be unspoken or ambiguous.
Yeah, I mean, there still needs to be avenues for the district if that person doesn't follow those parameters. I agree.
What about this idea of examples of what needs to be an example of a mutually agreeable situation? Would that help with the assurance that, you know, after they go through the AD process, if the ADA process doesn't work, you know, is there any reason to maybe say valid reasons may include?
I
But
don't
not-
know if that test, can we pull up our interests real quick that you had earlier?
Yeah, and then.
There's an interest that I can't think of what it was on the top of my head, but there's an interest that doesn't
And
meet.
John may have to read it if you don't find it here.
I think it's on that one because I remember reading it on the screen.
Okay. Oh, that's not Jaws. Hold on. Did I already have it open? Oh, I opened it from the body of an email. Here we go. There we go. Okay, so I may have to make it a little larger for you guys. Sorry.
You're fine.
Okay, there we go.
So it's that last one, respect that there will be unexpected situations, opportunities that are unpreventable. So I don't think we're meeting that interest with that.
Oh, yeah, gotcha. Because
Yeah.
you can't list everything, and that's
Right.
the problem with lists.
And
Okay.
things are gonna come up, and then what I fear is gonna happen, it's gonna get noticed by one side every single year because of every single situation that happens.
Right.
We want, and what we've talked about in here is this interest of wanting a certain amount of flexibility and leeway for that category while making it more objective in this medical realm.
Right.
And I just haven't come up with a better idea than the idea that I already had. But the best idea should win. And I just haven't gotten to a better way to make it objective while still balancing contract rights on both sides.
So I think maybe this comes out, and I'm not saying we're done, I don't think the answer's up here on this brainstorm ideas yet. I don't think the clear answer's up here, but we know this comes off.
I agree.
No one, I don't think, wants to list,
Oh my God, no.
No,
No.
we're gonna have
We
a
can't.
10,000-page contract.
We can't, yeah, we can't do that.
and it may be a combination of a couple things and some things you haven't thought of yet, but anything else come off at this point? The may to shall, I mean, I'd say if you were true to IBB, saying the district shall let people off, like just carte blanche, then you're going to harm a lot of interest. So,
I would also say, though, so with the shall, I mean, so if you read Rachel's TA, it says, in the event that the district and the professional employee reach a mutual agreement that the professional employee cannot perform the essential functions with or without job accommodations, and the professional employee is not eligible or has no available FMLA, then the professional employee may resign. If we change that to shall resign, I mean,
I intended may to give them the right to pull that trigger. So once we get to, and here's
oh, I
where.
got you. May to shall doesn't obligate the district, it obligates the
If
employee.
the employee gets to pull that trigger. And here's where, again, I think if we're in this hypothetical where there's a disagreement and we have some very unsympathetic, mean, weird HR person on the other side and this employee in a terrible situation, and we truly are at a spot where there is I mean, we haven't made an agreement on accommodations, and the argument is that right is now triggered.
right, I don't want it to say
Okay.
shall, and HR comes in and says, no, you shall resign.
Right, I got it. Okay,
That's
so
not what we
I
want.
read it as the district may let them out of their contract, and we would change it to shall.
A lot
Yeah.
of stuff happening right
So, the idea would be, add language that says the district shall let them out.
Or the employee
So it's not.
has an
really-
entitled, I mean, I intended may to indicate entitlement or
I see
right.
what, yeah.
So we could make that clearer.
No, I think that was my bad. When I was just glancing at the language, I couldn't see very well, and I thought it said the district may let them out of their contract. And that's why I said you'd have to change that to shall.
No,
if
I
you wanted
know.
to.
Right, I see what I see your thought process on that.
But it
Again, because I
wasn't.
want it to be the employee's choice,
Right,
not the district's choice. The district's obligation is to try and accommodate you. And if we're at this point where we're like, we can't, there will be record of that, right? Then the employee has that right to pull.
But we could add language that says district shall let them out.
right.
Expand liquidated damages, I think kind of goes hand in hand with this bottom bullet idea. Expand the time frame, not
I agree.
necessarily the dollar amount. Language in the contract demonstrating a commitment to applying this process and/or the approvals under this process equitably and objectively.
And that was added, right, that highlighted part?
Well, I just put mutually beneficial agreement part as the part that you guys, I think, are fearful that,
No,
Christie's talking about the
in the
TA that
TA, she added that at the bottom.
Rachel added some language.
oh, you went ahead and added that? Okay. I just didn't see it, but go ahead and share if
I'm
you'd
gonna
like.
jump the gunner, and when I think of things, if I don't write them down, I forget them.
Does everyone have it up, or do we need to screen share?
I'll screen share, let me.
Yeah, thank you.
Okay.
Quick.
Do I need to unplug, or will you just override me?
Let's find out. So again, thinking back to our previous discussions about how do you do a medical exemption right, that is language that I thought of, is like, the purpose and intent is that we treat these issues objectively and then everyone gets treated equitably. So for example, if two employees came in and they both, to make it an easy example, said, needs in-person treatment 3 days a week, and the district, mutually agreed that that couldn't be accommodated for one, but not for the other, we'd have a P&A violation based on this language that I added.
I'm guessing people are going to think it sure doesn't hurt to add this, but does it address the issue? And if not, what does? This is, I guess, heading in that direction. What are you thinking, Amber?
I'm thinking add liquidated damages for just this one situation.
I don't think that that meets our interest of preventing abuse of any exceptions to the late resignation provision. Additionally, this group's worked really hard on liquidated damages to get to where we were at last year, and throwing liquidated damages at another point, I think, seems confusing, or could seem confusing.
I do want clear paths, and again, I've talked a lot about the awkwardness of it, because this is an awkward thing. Like, it's very awkward, and I think it's more awkward and weird when we're saying, like, okay, you have this medical condition that's ADA qualifying, and so pay us to get off your contract. I don't like that. I just feel like
Well,
that's
and why would we tell if the accommodations can't be met and we can't have that person in the classroom, there's going to be a separation agreement. I mean, the language is there. So triggering a liquidated damages that says, no, we're going to make you pay when, well, there's a mutual benefit on both sides. If accommodations truly can't be met, seems punishing to the employee, I guess.
Like someone with a mental health issue going on might be able to afford, and the next person might not. If I had a mental health issue and the district wasn't letting me out, and I was married and 2 incomes, I would say, hey, let's just pay that so I can leave. I was perhaps single, maybe 1 income, having the same mental health issue, I might not be able to afford to get out. So I don't know, does that do something with equity? Do you know what I'm saying?
And we want to do everything we can to work with that teacher, that staff member, to keep them in the position, but also in the right way that for them as well, that meets their needs, that are outlined through the accommodations process, that are mutually agreed upon as the language says and is spelled out in the ADA process.
Let me go offline real quick so I don't accidentally show something that might be confidential, but I think looking at the ADA form might be helpful for us. Let me pull that up really quick. Because I think when you see how it is, like, I think it's the closest we can get to a doctor's note to get released from your contract, right? While still requiring that interactive process to happen. Okay, let me try and find it.
I think my issue is that we say we're going to release people, but we don't. And then they just have to leave their contract, and then they can't really go back to teaching because they have to, when there isn't a teacher shortage, then people don't have to hire them, and they have to mark on there that they were terminated. So that I need to have an assurance that people can leave if they do not feel like they can come to work and do their job. And what it currently says, they are not required to release them. They can tell them, in a way, we don't believe that you have a mental health issue. We feel like you can come to work every day. We're not going to release you from your contract.
Right, and I think the reason you guys wanted to try to follow FMLA guidelines and ADA guidelines, and it made that less likely to happen. Right, it meant if you do the paperwork that we let other people leave on
But even
based
if
on
they
the law.
follow the guidelines, they can still decide that they're not gonna let them out of their contract.
So what might
Which
the
is-
solution be
I-
that doesn't harm your other interests?
I cannot make this bigger, but if you can read,
It's okay. That's it.
I made this form, okay?
There's a magnet.
See that plus?
Oh, Okay,
Yeah,
Other one, the plus one.
There
there you go.
Huzzah.
read 6A. So, if we have a situation where the physician checks no, it's not an automatic out. It's come to the table with human resources. Okay, let's talk about it. Your physician checked this. Can we at least try and explore these things?
And then you say no,
Why,
they cannot get out of their contract. What is?
So if that's checked and we say no,
no, there.
that's a legally messy situation. Okay, like, that I don't know is legal risk that I would advise the district taking on, okay? That's what I'm telling you.
So if it's checked, if the physician checks no,
Yes.
and then we go to 6B, and that's the meeting, correct?
Yes.
Okay, so then the district's the ones that determine whether or not the number of weeks, number of months are permanently? Or is
No.
that still the physician?
That's the
So,
physician.
Got it, sorry. I
This
was
is
making-
all
making sure.
about-
This whole form is the physician.
This
Okay,
whole
cool.
form is the
Because I
physician.
was like, wait a second. Okay, got it. Cool.
Okay, so,
So they'd mark, no, they can't perform their job, number of weeks for forever,
Right,
permanently.
permanently.
and then what we say, because this is flipping what
Yeah.
Nolan mentioned on its head, we say, sorry, we can't, it's not reasonable for us to provide you indefinite forever job protected leave.
Right,
Now we're at resignation.
okay.
So again, this form is for, usually it is used to ask for very potentially high-level accommodations where what the employer is going to be pushing back on is the burden caused on them. This is sort of the opposite situation where this is what we're using as a process, is this certification form, and it specifically has spaces that allow a physician to indicate a very serious high-level inability to work.
So 6C is where the physician would say what the accommodations are needed. So they need to work 1 day a week, they need breaks every 5 minutes, whatever
Right. Any
accommodations they wanted to write. Now, if the employee didn't agree with what the doctor wrote,
Right.
Right.
then they need to take that up with their doctor.
Yes.
But also-
But what's on that form would be part of the interactive conversation that HR would have with the employee to see what accommodations we could put into place in the workplace to help accommodate them to do the work that we need to do and meet the job description.
So if they check no, and then it says permanently,
We are not going to substitute our judgment for a physician. We are going to make an effort with that first-year teacher to say, are you sure you don't want to try these ideas? And if the teacher says, no, this is my medical form, then we check the ADA box, we are at the mutual benefit exemption.
okay.
I'm not sure the district, Rachel, correct me if I'm wrong, but I'm not sure the district wants to put a teacher in a classroom when their doctor says, no, they can't perform the essential job functions without accommodations.
Oh, I would hope not. Oh my God.
Yeah.
But
So
at
if
the
somebody
same-
showed
I'm
up
just-
with,
I'm just asking. I'm just
yeah,
asking the
yeah.
questions
No, good.
because
We should all
the
be-
way that it's phrased is there would still potentially be that meeting, which again, okay, absolutely be like, hey, like, is there anything we can do? I
Correct.
get all that. I'm just
Correct.
I was just asking
Yes.
those clarifying questions,
Yes.
so it's not just an automatic like, hey, here's this, I'm out. Like,
Right.
and I'll be honest, I don't know how many, and I haven't been doing this that long, I'm not sure how many ADA forms I've seen with the no box checked. I'm not sure if I've seen any in my 3 years.
Usually what it says is,
Yes.
needs to allow teacher to work from home.
okay.
We can't do that.
Right.
Right, it's things like that that usually end up being the rub, or needs 3 months off. You know, and that's probably a worthwhile discussion to have. We probably can't do that. We could probably do 2 weeks unpaid, you know, like, so,
But if they qualified under FML, they could get that because of the 12-week thing.
Correct.
Okay.
correct.
Sorry, I'm just trying to do things in my head right now, and it's hard.
Yeah.
Okay.
I feel a little better seeing this form. My only, again, I am thinking a lot of worst case scenarios here, to be open and honest. You typed this form, correct, Rachel?
Yes.
How often is it updated?
Anytime the law changes,
Okay.
And I'm on like 10 listservs that give me
Right.
notification when the law changes.
And I
Well,
highly,
finish that track of thought. You may have something. I'll be on
I
this.
highly, I doubt you would ever, I'm trying to phrase this and I doubt you get like, oh, I'm going to delete that line.
So there are, I
That's
get
where
what
I'm
you're
going.
saying, I get what you're saying.
Yeah.
If we're making this decision based on a form is not part of like.
It's not part of the
Okay.
P&A is kind of what I'm saying. Yeah.
So the EEOC is the one who administers the ADA process. There's guidance everywhere about what the form has. I mean, I didn't just make this up from scratch,
I think,
right?
yeah.
This is like, the EEOC says your forms need to look like this and have these things. And even if you have ours, because I'm, as you all know, a very like, obsessive compulsive person, I made it very like clear so that a physician would be driven to write certain things. Other schools and other employers might have just like this sheet of paper. But in any of those sheets of papers, whether there's these prompts or not, a physician could write, I don't know of any accommodations that would enable them to perform their job duties, whether it's there or not. I just checked all the boxes that the EEOC told me to.
Right.
So, I mean, there's not, you can't,
I can't. I can't.
you can't limit as an employer and a physician's ability to say that. That would be an ADA violation, if that makes sense. You can't limit it. You can't say, I'm sorry, physician, you can't tell me that.
Right.
Leanne told me not to have this meeting on this day. Just Dr. Neal was like, no. And I was like, I'm sorry.
Noted.
11
Sorry,
people
yeah,
can meet
we'll
on this
remember that
day.
scheduling out next year.
I need to warn you that this was happening this week.
It's a lot of stuff going on right now.
For those
My time
potentially
with
watching and
advocacy
can't hear,
work,
there's a
what I see
band
a lot
playing
on there
outside.
is They need to be able to break as needed. Is oftentimes on stress leaves or stress accommodations is the employee needs to leave the workplace as needed. And that's probably not possible, but that's the most common thing I saw under those kind of.
Yeah, you get some things that really require that interactive discussion because it
Right.
needs to be able to call in a fellow coworker at any time. Well, that's supervision issue, you know. But you're supposed to do what we do in this room, which is have those hard discussions and be creative and figure it out. But if you've got, permanently and they're unable to perform their job duties, like that's probably going to be a very short discussion. But again, I want to give that first year teacher the chance to maybe ask, right? Like,
Do you, if you've ever had a meeting where it's not been mutually agreeable, if you have, do you then provide the reason for that?
well, again, usually it's flipped. Usually the employee wants an accommodation and the district is like, sorry, that's unreasonable. And then we would describe why. The cost is this. It would change our schedule too much. It would burden your coworkers. Like, we would have to provide that.
I don't know if people need to have time to kind of think on this, or are there other ideas? What you've got on here now is just language in the contract demonstrating the commitment, to demonstrate the commitment to, equitably and objectively applying this. We can mess around with those liquidated damages related to if someone doesn't have mutual agreement, then if they pay, they can go, and maybe with time frame given. And I still have left in there, add language that says the district shall let them out. Are there other ideas?
Can we just keep the current language that we have, or is that not possible?
What
We
was
brought
the
it
current-
forward because we can't use FML for those employees. They're
That
not.
don't qualify.
They don't qualify for that process.
And
But
so-
everyone qualifies for ADA, and the reason I like this is because that's an option for you, even if you are FML eligible, and that steers you there, because you should be steered there.
So you wanted to add FMLA language in there so that you had some way to objectively judge a
Objectively.
medical situation if
Yes.
they're not qualified to have FMLA.
Because what other school districts are doing, from talking to my colleagues, is someone's wearing the God hat and making that call. And that results in inequity versus relying on these forms that a physician has completed and given the employer information about.
I mean, I know it's a given because it's the law that you cannot replace the physician's opinion with your own, but it's something you could state. If it gives people more comfort level, I don't know. I'm just trying to think of what you can do contractually, because dealing with the concern that, and I know a lot of groups I work with, they say, I don't want to rely on people like Rachel and others around this table. I want to rely on process or contract, right? Because people change.
How about that?
Where language has to bargain to change,
According to the information provided by their medical provider.
And if anybody feels as though there's an interest that's not been put up here, remember the only interest is a hidden one, right? So if someone is there a fear that if you go to your medical provider, they will not say that you're having some mental distress? Is there another reason someone might want to resign, that you want them to be able to resign without going through this? I mean, that'd be an interest. What is that interest?
I don't think the issue is going through the process. I don't think that's the problem. I think it's the problem of when we come to the position of when our new teacher wants to, or a teacher wants to leave under it, and we get to the point where the district's not going to allow them to. That I think is where we're at.
So then you could go back to current language. You could also say no late resignation, because wouldn't that ultimately result in that? No limit on late resignation. No, there is no such thing as a late resignation, then you'd say. If someone can just resign whenever, without...
I mean, we had that before. We just had liquidated damages with it.
Right, so that's on the thing. We could talk about...
Oh, yeah, sorry.
That's one of the ideas. Go back to liquidated.
Yes, yeah.
So what if we try this and sunset it? We try it for a year, sunset,
Yeah.
and then
But
see if it's meeting
add
our
the stuff
interests.
in yellow, I'm assuming.
Yeah, with the yellow, I will say, thank you for showing the ADA form, that makes me feel better about some of my concerns, I will say. But if we sunset it, revisit it next year.
Well, then we can also see any potential abuse that might,
Yeah.
Right, 'cause I
come up
think-
from it. And then it's not, because again, if we're going to input, that way we can at least look at it all the way.
Well,
So
I
I'd be
don't
okay
think
with
you
that.
would, you could look for abuse. I think what you'd be eyeing for is...
Or effectiveness.
Unequal
Inequal, yes.
application,
Yeah.
right.
So,
Or what
because if it
denials.
works, cool, and if it doesn't, then let's
And
fix
again,
it.
because this has been, we renegotiate this when we have situations that don't work. The situation we had where it didn't work was where someone was actively and outwardly seeking employment elsewhere, and we were getting requests for recommendations that is the district's nightmare scenario, right?
Right.
Yours
Right,
is,
right.
I can't do this, I can't work anymore. Ours is, I found something better mid-contract, sorry, my students and my coworkers. That's our nightmare situation that we don't want.
Right.
Because again, if you're an administrator, you're like, you signed up for one school year, do your school year.
Well, if you're a
Now,
parent...
I know that I've been there, I've experienced extreme job stress where going on for even one more week wasn't something I thought I could do. So I know that exists on the other side. And so it's, how do you catch that? Oh, I really just realized that I don't love teaching and I can make more money somewhere else. Those are outlier situations that end up with us having to create this
Right, absolutely.
structure.
I'm okay with it.
We want our teachers in our classrooms, but we want
Oh, for sure.
we want our teachers happy, healthy, and in great places as well. And I can assure you, in every ounce of me, that we will be thorough and honest and equitable and honest with every conversation that we have with staff members, and hold that we will recognize everything that employee is saying and take that into the absolute fullest consideration. I hope I'm saying that in the right way.
Yeah.
I don't want there to be any doubt of, oh, the district's just saying I got to go to work. No,
Well, I know,
that
but
is not
I
what
think
we.
people are also concerned, what if you're not here?
Yeah, it's not so
It's
much
not,
you,
you know what I'm saying?
it's the.
So that's
it's
why
just-
Well, I'm going to a new position, so I'm going to be. I can assure you, I'm going to be here. So.
Right.
But I mean, I think...
And it is long-term. We're not thinking
100%.
short-term. We are thinking long-term.
100%.
But I'm good with it with that last, I'm okay with looking at it, and then sunsetting.
Yeah, let's see, does
and
it
then
work?
going from there, because if it works, cool, and okay, and then if
Amber,
it
what are you
doesn't, let's fix
thinking?
it.
I'm fine if it sunsets, but I also think that there are sometimes jobs you can go to that don't require you to work with children, but you can still continue to work. So I think that that was actually the real situation that happened there, is that sometimes it's difficult to work with children, and that is why you have to leave a position, because that can really affect your mental health. But you can continue to work in other professions.
So that person's doctor needs to put, no, cannot perform this, or yes, but remove children from classroom, and then they would be released from the contract. I mean, some of this is about educating your membership.
I don't know, I'm not gonna agree to that, Stephanie.
You know, it's, and some of it is letting your members know how to make the policy work when they need it, right? Not abuse it, but work when they need it, and that's why there are some perimeters. I feel like you've got it, you're on a track there, but would it be, you would have the option of sunsetting as a group after you reviewed how it went, and do you want to kind of include that in some sunset language, that there would be some assessment by this team of not violating HIPAA, not giving
Right.
any names of any, right?
Well, I think there's gonna be data. I mean,
I mean, we can pull what, we
We
can
were
pull
gonna
late
review this
resignation
anyway.
information.
Right,
Yeah, I was gonna say,
exactly.
And we
We're
can
gonna
pull
bring
late
in-
resignation anyway, so that's not, there's no,
Okay.
without
Yeah.
violations, so that's not.
Right, I mean,
I know
that's
for
actually what I was
reasons.
looking for. I was
Yeah.
looking for the number of, you know, mutual
Mutually, yeah,
separation
separation
agreement
agreement, yeah.
resignations, which
Right.
I
So
think
that's-
maybe
and
were
again,
higher
Right,
this year
but I mean, if you
anyways.
had to get into reasons why and was it applied equitably, you can just black out names.
Absolutely.
For sure.
Absolutely.
I mean, I feel like just third-party perspective, this is a safer thing to trial than the other side.
Agreed.
The other side is wide open, and if you trial that, teachers are going to be pulling their hair out
oh, I agree.
with people just leaving.
Yeah.
But it gives you guys the ability to try something and to keep focus of work on this.
Yeah.
So, is it, when did they get that ADA form, when they contact HR?
They're just given a copy of the, there's a.
And it's on the website
It is,
as
that's what I was
well.
going to
Oh,
ask.
okay.
It's on the website under the HR, so.
So people can have that in hand when they go to their doctor, and they're probably going to have a more successful conversation if their doctor has used the form versus just a piece of paper.
Yes.
What do we want to do in terms of the language for sunset? Do you guys usually put your sunset language embed it in the body of the contract, or do you?
I just used what we already, like, for the two provisions we have that sunset, it just says it'll sunset at the end of the school year, which means this whole thing goes away unless we do something.
Do you have to say unless mutually agreed upon?
What we will do is next year when we negotiate, that'll come up as one of the things that we have to, because
Right.
neither side's gonna want that to go away.
Yeah.
So that's how we typically done it, is we use that word, so when you do a word search, it comes up.
Right.
It wouldn't hurt to make yourself available with NEA leadership to train your building reps. Yep.
Yes.
Oh, for sure.
We have to do thumbs. We finally did get to an idea. Thank you. Figured there was something in here. And it really doesn't, you know, sometimes people think sunset things just kick the can. It's not. It's you all trying to like be super, you know, intentional and mindful about doing the right thing. So I think this sounds good. But do we want to do thumbs on this language?
I'm ready to thumb.
Okay?
All right.
I will send it, the revised version to you, Amber.
Perfect.
I'm going to go ahead and save the document that had these ideas because you may be revisiting these ideas. So I'll put sunset language was TA today, but I'll leave the rest.
This is, I think, our second or third TA on this one. And I will tell you guys genuinely, like, I hope that we've built a trust, and I'm never going to try to pull something over or you know, slide something under the table. Like, I'm never going to do that. And it's frustrating when we go back and look at things. But it's better to do it now than after, you know, June or something like that, you know. We're
Well, and
sending
again,
something
it's
for
not
ratification.
a personal thing. It's just making sure that if you guys aren't the ones that we're talking to, it's there. So
Yeah.
that way the new people
And I get
It's
that.
there. It's
I get
us,
that.
so.
Jeremy and I want to retire someday. so.
Absolutely not.
Nope.
Has everybody had an opportunity to review the revision for
But you're not
the pilot program for PLC? I sent that out. And if you don't have time for that, I literally just, the only question I
If I send you
had,
these, can you put them in y'all's shared drive, the solutions on this, what we just did?
the only question I had on that, because all we're doing is deleting out the other option, is
Right.
I wasn't sure if, with the option we're doing, if it's correct to say this 4-week average of 900 minutes. Is that still correct? Yeah.
My question is that just for the classroom teachers? Because if you're a special teacher, art, music, PE, library, your PLC is happening like in the morning, you know how they're doing that? So then would they still be guaranteed their 230 minutes of plan per week? Like same with maybe a special education teacher, ELL teacher, all the other teachers that aren't PLCing during their plan time? Because right now, the elementary school classroom teachers are going to PLC during their plan time 1 day per week. So that's why their monthly average would be 900 minutes. And I actually think it's 890, but that's another point.
All right, how about I figure that out?
Okay, sounds good.
Yeah.
Thank you.
Okay, I will figure that out, because I didn't know. So this average is actually lower than what they would get under the previous P&A provision?
No, I think we had a typo. It was written out either in Word as 890 and then a number said 900, or maybe the number said
This
890
should
and the
be-
word said
This should
900.
be that, but then we still have a question for,
And I think we just have to look at the box, because I think when you add it up,
okay.
I think it said like, if you only got 4 plans a week and the 5th one was a PLC, that would be 200 minutes a week, right? 50-minute plan, 4 days a week. And then you'd get a staff meeting every other week to be used for plan time. And I think on the P&A, it says like 45 minutes. So 45 and 45 is 90. So it would be 890
Yeah, you're right.
for 4 weeks.
There's our math teacher.
I'm not.
But I guess my question is about the staff members who are not doing PLC during their plan time. Could they, with the language previous to that, 230 minutes of plan time per week still apply to them?
And that would be
So
special.
doesn't this just say at least 890? So those special teachers would be over 890, right?
Yes, but I guess my concern is that a principal could say, well, I'm just going to make sure I give you 890 and not give you the 230 each week. Because the language allows it. So that's my only
Yeah.
thing on that.
What
Sorry
might
to
be the
enter
fix for
into
that?
debate. What?
Is it just an interpretation fix? or
No,
is it
they were
adjustment?
previously, we kind of both took a hit on this, meaning that we lost a staff meeting, but they lost some amount of plan time. So it's like if it's not necessary for certain groups to lose plan time, then they should maybe still get that plan time. And Jeremy's right, it says minimum, so in theory, principals are just
Yeah.
Right.
giving it to them, but maybe we need to clarify for different groups, like plan time will not be impacted for, or something like that. Okay, I'll do homework. All right, that's our first two.
So does elementary, that was what you were looking at, was elementary PLC?
Yep, and I
Okay.
just wanted to.
Does it need to come back one more time?
Yeah,
Okay.
I'll bring it back at the beginning. I will send it to you in advance of that meeting, and then hopefully it doesn't take very long.
Okay.
Some sums.
The other thing you guys had on here, I'd say have a break, but it sounds like there are folks out here and we're done in a half hour.
I am
Let's
not
just
walking
keep
out
on
of this
pushing.
room.
We're
Um,
going.
We
That
had
is
committee
too much
reports.
stimuli.
We had the leave committee.
Yep, I'm happy to give a report on the leave committee, because it's going to take about 1 minute.
I was gonna say, it's not gonna take long.
So we've met twice and have had very productive conversations related to the temporary leave provisions. And we are not ready to report out any recommendations. However, we are really honing in on 2 particular solutions, or potential recommendations, I should say, not solutions. One around having a certain number of days, employees having to have so many days accrued before they are able to sell back temporary leave days. So that being one of the solutions, and then looking at a potential recommendation for looking at mechanisms to be able to add days to employees' accrued leave bank. So those are kind of the two things that our group has focused in on, and we've made good progress and had good conversations. So.
And do you guys want to have those recommendations done by the next meeting, which is 5:15, I think?
Yeah, I
think there's a good chance.
I think there's a good chance. We've got some behind the scenes work that needs to happen to see if these are feasible or not. But I think we would love to be able to bring something to the greater group.
Yes.
Yeah.
Guys, was there another committee report, or are we moving on? Go ahead.
Special, it's already up.
I just have to give our subcommittee props. We have worked really hard and quickly. Efficiently.
Very quickly.
Yeah.
So good job, guys.
What's up? Give us your report now.
All right, that's me. Okay, so we had our special subcommittee proposal, or we've met 2 times. And so here are our interests that we had. Do you want me to read through them, or can I just?
Or leave them long enough for people to read.
Okay. So these were our interests that we were trying to meet. Is everybody ready for me to flip? Okay, here is our interest statement. How do we ensure elementary specials teachers have a daily schedule that allows them time to plan, modify lessons, contact parents, collaborate with colleagues, etc., to successfully meet the needs of all students? And here are some of our considerations. So if additional planning time is going to be considered, it should be equitable across all elementary staff. So when we got into this meeting, we were like, wow, this is like an elementary issue, not just necessarily a specials issue, and that if we're gonna add plan time, we need to add that for all of elementary. So that was one of our considerations. When we got in there, we decided that we needed to add a representation from the elementary classroom educators, because what we're doing with specials teachers does affect the elementary classroom teacher. We did feel a little rushed to find a solution before the end of the year, so we are making some little steps, and I'll go over those. And then also, due to the extent of the issue, we recommend that the workload would need to be noticed as an elementary issue, not just a specials issue. If solutions involve adding plan time, we recommend further work to discuss determine solutions, and we would like to start meeting like at the very beginning of the school year as this subcommittee. So here were some of our recommendations. One of them was to prioritize planning time in blocks of 30 minutes or more. So currently, like in the contract, it says 20 minutes. And so we were wanting to guarantee that people have at least 30 minutes or more. Hopefully they would get their full amount of time instead of having it split, is what we were thinking. We really want to prioritize planning time at their home school. So like if they were traveling teachers, we really want them to be able to have their plan time at their home school building and not have to do it at the one they're traveling to. We would like to prioritize 1 day a week to be duty-free for traveling teacher and the home teacher to collaborate and plan together. So what that kind of looks like, instead of them having a duty 1 day a week, they would get that time, that would be the duty time at the beginning or the end of the day, to collaborate with the person that they are traveling to their building or the person that's traveling to their building.
Remind me, what's their position? Is that like helping kids get out of the cars in the morning?
Yes,
Okay.
it could be any of those things, like walking people to Y Care. It's just a duty. Prioritize traveling at the beginning of the school day or the end of the day, not having to leave in the middle of the day to travel. And include representation from specials committee on the PLC subcommittee. So like our thought was, we felt like when we were doing the PLC subcommittee that we were working towards getting teachers more plan time. And so we wanted to be able to have a specials teacher on there or some people from ours to kind of help with that whole big issue of like getting plan time for all of elementary. Like how do we figure that out? So that was our last one. And if you have any questions, so that's kind of just our recommendations that we had at this time.
Pam, who was doing this? Anything? Did a great job, I'm following what you're.
Yeah, well, first, I just want to say thanks to Amber for her leadership with the team. She did a great job organizing us and keeping us on track. And I thought we had some really productive conversations. And while sometimes we can't solve the ultimate problem, we definitely came up with some recommendations that we can prioritize and take the lead on that with principals in working towards these things. And I believe many of them are doable. It's just about diving into schedules and setting that expectation. And I think some of the things that we discussed just had never really come to the forefront, and we didn't look at it through that lens and have that idea. So I feel like we have some really good ideas that are going to help with some of the areas we had concerns. A lot of that was the traveling teacher being able to collaborate with the teacher they're supporting, and just that arrival time gives them that extra time till that 8:10 to 8:30 they already have, but being able to start that at 7:50 if it's not their PLC day. Really some things that really, in my eyes, seem pretty simple. It's just about planning for it, so you have others on duty. And we had a couple nuances with scheduling that we didn't really realize that were going on. So I think the other thing that came out of our discussion was just coming to each other and talking about things that come up and seeing if we can problem solve sooner. But also just really some good ideas and conversations around this, and I think it's going to change some of the ways we look at things and how we can prioritize that scheduling.
Other questions?
The fourth bullet point on there, I just have a question. Do you mean if someone is a traveler, you will prioritize just having them travel in the mornings? And not like on an A day, I travel in the morning. On a B day, I travel in the afternoon. On a C, you know what I'm saying? Is that kind of what the idea was? Or?
I think the discussion there was maybe we had one situation where, and also a lot of this is working with building principals and figuring out space availability. So, you know, that was one of the challenges when we were talking through some of these things to say it's guaranteed or this can happen. You know, it might be a space availability piece and we're not aware of that. But what we were talking about was we had one situation where people weren't traveling at the beginning of the day or the end of the day. They were kind of like next to the end of the day hour, which then was causing them to not have planned time in their home school. And so we said we need to gather more information about that to understand why, because if we can make it at the beginning or the end, we want to. But also it could also be because of space availability, because it is with one of our largest schools. So just those things that we're going to prioritize and try to work through. I think we already are doing a pretty good job of that, but maybe a couple nuances out there that we need to put our heads together and see if we can come up with a plan. And then that last one was just that we felt like we were getting into discussions that if it was around workload, we felt like it really was more so that it needed to come to a whole committee because we couldn't go out on a separate realm and just discuss that for specials teachers and talk about additional planning to cause an inequity with all elementary teachers. So that's why we thought some of the people that have been doing the work on this, if they could join the PLC, then it would all be one group instead of separate and not being on the same page with communication.
What other questions or comments? So I just want to, for the purposes of facilitation, I want to sort of seek clarity. So these were the recommendations that came forward now to the IBB team to prioritize these things in some way? Or are you saying that you all have sort of, as a team, figured out how, as you go forward outside of IBB, these things can be prioritized? Which, I mean, how do you make these actionable? Is actionable have to be up here, or can actionable without?
I would like to change the 30 minutes, the minimum 30 minutes for sure, like in the language, because like it currently says 20 minutes and I'd like it to say 30 minutes. And we could do a sunset thing, try it out for 1 year and see if that, but I for sure liked I would like people to have at least 30 minutes of plan time and not the 20 minutes that's currently in the contract.
So then,
for me personally.
And about the rest of the recommendations, are they executable outside of here? In other words, is that the only one that relies on action from this committee, or can the others be done?
I think it's not a district question because we don't get to make the schedules.
Prioritize.
Right.
And prioritizing is kind of a process versus you know, so.
Correct.
Right, and I think where the recommendations came from is we all identified these as priorities, and that if we prioritize these, we could alleviate some of the stress that was being caused, that we could really work towards alleviating and making that better, whether it be the collaboration time, whether it be the travel, of course, and the planning in your home school. I think the piece about the prioritizing plan time, that our goal is that when we're scheduling, we would want it to be, if at all possible, 30 minutes or more. Don't just settle with, oh, we can fit 20 here and we can fit 30 here. That's a prioritized item, but to say that we could do that with every single staff member and every person that travels, we didn't study enough schedules, we didn't get enough input to be able to know that. So that's where we're saying that we're going to prioritize these things with scheduling. And when you're saying, can we do this outside of IBB, I'm saying yes, because as part of our administrators and their training and our overseeing their scheduling for the next year, this is something we would review with them. We would talk about the priorities of what we have when scheduling, and then we would review their schedules to see, have we worked to meet these? Do we need to problem solve anymore? So that's how we would work on that as building leaders and district leadership supporting that, and give them the why behind these recommendations, because I think that's really important. They weren't involved with the conversation that we had, and helping them understand the why as we make these priorities.
And then earlier screen said that this committee wants to start meeting sooner. To come back and continue to track those recommendations, and possibly others?
Yeah, I don't think we found a solution to this yet. We wanted to come back with some recommendations to put in place for next year. I also think I think part of it is also we have one elementary school that has a lot of sections, and the boundaries that's like kind of being split. I'd like to kind of see like how that plays out, like how that relieves some of the things that are happening. And I think we're like a year out from that to kind of see what that looks like as a solution, because we don't know what that's going to help do.
So the prioritizing, it sounds like it comes from direction for individual school admins, get this direction in a way that they need to prioritize it, and then some checking in, did they and how's it working? Except you're saying, Amber, you would like the IBB team to entertain the idea of, could we just put 30 minutes in the contract? I'm hearing you say, don't know if we can commit, don't know if it can work until you try it, right? So let's talk about that. And then the rest of them could be prioritized through direction to admin, is that right? That's the only one, I know, I'm just trying to figure out what all we need to put on the agenda out of those recommendations.
Well, if anybody else would like to say anything. For me, the biggest thing for me is adding the 30 minutes. If anybody else thinks we need to add any more language around the other things, we could just try it out, see what comes from that.
I agree. I think out of the things on there, I don't want to use the word easier, the most feasible to add, to change language on potentially would be the 30 minutes or more. The rest of them, I see a lot of struggles of potential right now. I need to think about it more.
And I would have to say that we would be able to adhere to that in every situation and put language in the P&A. We didn't spend enough time studying schedules and understanding the nuances of everything. We really just talked about elementary specials, and even then, we didn't dive into schools' individual schedules to understand blocks of time that are available, and that doesn't even go into any other travelings.
I guess that would
Orchestra and
impact
bands or anything like that.
budgetary items. I mean, you increase that amount of plan time, that could lead to, okay, well, this teacher now can't travel to this building or this building, which means we have to now hire this teacher and this teacher, which was not budgeted for. I mean, yeah, we could change the P&A easily from 20 minutes to 30 minutes, but I think the implications could be significant for this group as we as we get into the budget items come next month.
And we've done things that cost the district money, done things that have cost the district significant amounts of money over the past 5 years, but have needed planning and preparation time to do that.
Right.
I mean, you guys mentioned in the presentation that it felt rushed. It felt rushed, so I'll just
Right.
bring that to light.
And I would say if we prioritize these things, as I said, with our administrators, and then as we are proactive on the planning side and focusing in on these, and then we review their schedules, problem solve around those, and see what we can do and roadblocks we run into, and then we can reconvene after we have those schedules in place for a while as a special subcommittee and talk about, did these things have an impact, and get some feedback from staff. I think that's a good way to go to understand if these things, first of all, could we do it consistently? Did we run into any roadblocks we didn't anticipate, or costs that would have been a problem? Or just kind of try it, make it a priority, and come back together as a team, but getting input from the staff that this actually would be a change for an impact, and get their feedback. But I think the main I'm sorry.
I assume changing the minimum block of plan time would still be on the table for that subcommittee next year if it was still meeting, right? That would still be something you would consider and talk about.
Right. I think we also, yes, but we also thought that it made more sense to be a part of the PLC and a group that actually, so the conversation was bigger and not a separate conversation that could impact something else, was one thing we discussed. That if we're going to start talking about plan time and those kind of things, we wanted to make sure that it was a bigger conversation than a subgroup just around specials.
So this recommendation would direct you in making the schedule to prioritize trying to do that. And so it's between that, what we're sort of looking at is between that and between making it a guarantee in the P&A for next year. That's the discussion point right now. Okay.
So,
I mean, my only hesitation is I like documentation, I like things in writing. How do we prioritize planning time, blocks of 30 minutes and all of that into writing for next school year? And I see your points. Like, we do need to test things out, 100%. But I do also want some avenue where we've documented that you will do that. Which, again, you're great, I know. But again, on the association, I hate to say side, but just kind of on our side, like, documentation is important.
So that's where we've done collective commitments.
That's where I was going, surprise, surprise.
That's what I think that we would do if we're not.
Why 30 minutes? And just from a secondary perspective, you know, a typical, at the high school level, 7-period day, it's 50 minutes. So if I'm just thinking from that perspective, why 30, why not 25? I know we're looking at a number that's more than 20, but I think at the elementary level, like band and music, that just comes to my mind because I've worked with it. I think those are 50-minute blocks of time. Is that correct?
Well, I think
It's each class, so like 5th
Special-
grade is 30, 6th grade is 30.
For specials, it's 50, but for
Band and strings.
band and strings, it's 30 minutes each.
So if going off the band or the specials, 50 minutes, okay, well, why not 25 minutes? That gives them half of those periods, I guess. Is there something special about 30, I guess?
I think what I remember from the conversation, and Amber, join in, is that really 20 minutes, it's pretty challenging to make that be as productive as you would want it to be. We all understood that. And so that's where we were talking about if we could prioritize that it be a 30-minute block rather than a 20 and a 30, or just kind of fitting in time, that we did a more comprehensive plan of really prioritizing 30 minutes. That was where we were coming from. But again, we didn't dive into individual school schedules and determine, can we 100% adhere to that in every school? And is there a reason why it's 20 minutes in certain locations, whatever that might be, whether it's space availability, whether it's another scheduling, but we would need to dive into that, and that's where we would say, here are our priorities, you're starting to set up your schedules, we're reviewing your schedules, basing it on these priorities, as well as, everybody having their allotted plan time, and then doing a review of each schedule with building principals.
So it could say prioritize planning time in blocks of more than 20 minutes.
And I think maybe to answer your question too, before the ABCD schedule, PE and music were usually split on one day of the week, and so it was only a 30-minute block of time instead of a full hour block of time.
Right.
So it sounds like there's real interest in digging into these prioritizations or recommendations. It sounds like there is a way to do it between now and next time you're together. Sounds as though you really need to plug the results and the work into this committee that you plan on expanding. And you're saying that let's take it serious. If we're going to really look at doing this, it may take resources, so let's commit to the process.
Correct.
What do others think? People who haven't talked tonight, what do you think about this?
I would agree with what they said. I would not like to rush this. I think that this could have a lot of implications that we are not prepared for right now. So I think that having the committee look at it would be my recommendation.
I'd like to say that I do agree as far as having some kind of documentation, that this will be a priority.
And I would say that we actually have to try to implement, like, we have to actually be setting up our schedules for next year and principals working through that process, that our committee meeting, again, is not impact, you know what I mean? It's not the committee meeting about this. It's about actually being able to make this happen as we build schedules, and then coming back and visiting it
When the
after
committee
we've
meets in
done.
the fall.
Yes,
Yeah.
after we've seen what we can do, and then had those schedules in place to be able to get a little bit of feedback, and so like a check-in, and then again, another check-in. Yeah.
And so part of that committee work would then be looking at the schedules, seeing if there was a school that couldn't make it work for X, Y, Z. I don't know those reasons, but if they couldn't, then looking at and making sure that the committee couldn't find a different solution to make that schedule work. Does
The
that track?
the administrators would be working
Okay.
through their schedules, because there's a lot of different caveats with that. You're working
Right.
with other schools, you're working with a lot of different aspects of
Right.
your schedule. In no way would I be able to be an expert, or our committee to be an expert on any one school. So I think it's a process that we would work with, and then have the directors that review those with the principals, and then problem solving around that.
Perfect. Okay.
But then I guess what I'm trying to get to is how do we make sure the committee has the information to continue to be empowered to work towards the priorities instead of just putting it all on you all? I understand it's going to need to be on you all to give administration.
I think that we'd come back together and
Okay.
report out, and we'd also get feedback from teachers that schedules changed, or that this directly impacted, like a traveling teacher, a teacher that collaborates with a traveling teacher coming to their school. So we would get feedback from them that these priorities actually impacted.
So the committee would then dig back in
Yeah.
with the information. Anybody else have any thoughts on this one? Do we want to have a collective commitment drafted to look at next time?
No.
Is there a template for a collective committee draft? Does anybody want to work on that? If you look at what I think Rachel's done before, so that, again, all assignments we kick over this way, and I'm trying to not do that. If you have the structure of one in place, and it may be someone that's, I hate to say
I
it, but on the
have this
committee.
presentation, Pam sent me a copy, so this is not a heavy lift.
It's not a heavy lift,
This is copy and
okay.
paste with the words collective commitment at the top.
And then maybe before you bring it back, you and Amber take a look at it, and then you guys bring it back here so we can thumb the collective commitment.
Yeah.
Is that okay?
Okay. And I can include on there that this committee will meet starting at the beginning of next year. I think that's.
I like that too.
Okay.
Can I ask you a quick question? Is this prioritizing planning time in blocks of 30 minutes for only elementary or for secondary as well?
Great question.
Yeah.
I feel like it's only elementary right now.
And do we want to say more than 20, recognizing that, any increment that can be larger than 20, if it is 35, 40, 45, 50, those are all
I think
better?
that is a better way to phrase it, based on what our goal was. We just said, yeah, if we can make it more than 20, it's going to be more productive. Obviously, more than 25 is going to be more productive. So, but I do think since it is listed as 20 minutes, it's a good recommendation that we say more than 20 minutes, and we work towards that, and we can talk about the why. Like I said, I think it's really important we talk with principals about the why and the discussions we had behind it.
Who else was on the committee besides you two? Anybody else here on that committee? Okay. Because, I mean, think about, did the committee really tune in to 30 minutes for a particular reason? Or was the committee saying more?
I wish it was the full 50 minutes at one time but the 30 minutes is because by the time you go to the bathroom and get back to your room, in 20 minutes, there's not enough time to get anything done. But in 30 minutes, I mean, you have 20 minutes. Like going to the bathroom, getting back, you have 20 minutes. I would prefer it be that you had your full plan time in one sitting. I know that that's not possible. That's why I suggested the 30 minutes so we can slowly inch it up possibly to be the full 50. I mean, I understand the implications, but for this first year, let's just see, can we get up to the 30 minutes and see how that kind of works out?
What's
was
full
my
plan
thought.
time?
50 minutes?
50
minutes,
right?
Typically,
50 minutes.
yeah.
So if you're going to split a plan time, that's 50 minutes, how are you going to split it? You're going to split it 25 and you're going to split it 25. You're not going to split it 30 and you're going to split it 20. If you get 30 in the morning and we're saying they need 30 minutes, now they're at 60 minutes of plan time. So from a mathematical perspective, that's where my mind goes. If full plan time is 50 minutes, I think we need to look at minds of 25 minutes or
Your
more.
plan time's in your contract?
Yes.
Does it say a minimum of 50? Or does it say shall get 50?
It's
the
an
so
average-
many-
230
it's
minutes.
Per a week.
Average
Per
of
week.
230
Oh,
minutes
okay.
per week is
Per
how it's
week.
worded.
All right.
So if you have 20 minutes one day, does that mean that you have a really long plan period another day?
Maybe.
I mean,
But not for everyone, like, okay.
Wow.
Because
It
that's
is a
like
mind
maybe a benefit, like if you get
I don't
an
know how you guys do that.
hour and a half plan time.
that's hard for me to answer as a classroom teacher because my plan time naturally is when the kids are at specials, which
Correct.
is 50 minutes long.
Correct.
So I know I can't necessarily answer that question.
So you're saying maybe the direction, your opinion is, up to, increase plan time as much as you can, up to?
The 50
Or with
minutes
the
a day
goal of,
being the 50 minutes a day, all together, not splitting it. I think it's very difficult to split your plan time.
right.
Yes, and be productive, because then
Yeah.
you're like, oh, let me do this, let me do, how
Or
do you
is it-
prioritize
so is
what
the
you're
issue
gonna get
splitting
done?
plan time, or is the issue the amount of, or is the issue the
Right.
20 minutes?
I would say our goal is already that we wouldn't have split plan times. So the reason
Yes.
there is split plan times is because
For
we
sure.
have to,
That's how it
right?
works.
To be able to
Yeah.
provide for that and a certain amount of plan to make sure there's planning each day. So I think from what I understand from the conversation we had, it was that 20 minutes, even though that's in the P&A, is really a challenge for it to be a productive amount of time. And we understand why it might be in there, and we know that we don't know every nuance around scheduling. But we would prioritize it that it would be 30 minutes or more if we could make that happen, right? But not knowing, can we make that happen without, but I see where Jeremy's coming with, well, what if we said prioritize in blocks of 20 minutes or more, meaning, well, more than 20.
More than 20 minutes.
More than 20.
Right, or you could also say prioritize the 30. If it can't be done, see if you can get to 25.
Right.
And then what would be interesting is then get the data back on what was done, right?
I mean, our goal is to prioritize 30 minutes or more.
Yeah.
That is what our goal
Okay.
was and what our discussion
Okay.
was. But can we do it? That's another question.
Okay, so then, is that clear on
Yeah.
commitment?
No, I mean, honestly, I know that took extra time, but I do think it's important.
Yeah,
Because
sure.
when we've had work groups that haven't had well-defined parameters, like what are we trying to solve and what are the parameters, that has gone awry and it's come back here to us being like, wait. So
Yeah.
I'm glad we
For
spent
sure.
the time.
Right, part of it is just sharing with the administration that the whys, like you said, and then give them some direction but freedom to try to see if they can make it happen. And then see what happens. Guys, the only other thing you have, and we only have 7 minutes, the only other thing you have today, how did we spend all that time on late resignation and still
Every time.
got to everything, except we didn't get to the MOUs? You wanted to review current MOUs to see, do they need to carry over, or does anything expire that you can let expire?
I was gonna say, we're technically
past
over.
it.
Oh, yeah.
So we need to
So-
figure out how to get to those agenda items.
Well, so then that's why I want to really build for what do we do when we start next time? It sounds like next time we can have a leave report, May 15th, that may have recommendations. Is that right, for the leave committee?
Yes.
It sounds like we'll review the collective commitment.
Tentatively, yes.
And it sounds like you're going to do some language changes you're bringing back related to, Rachel, you have some language changes related to something.
Well, we should be done with this TA on late resignation, collective commitment leave committee. We'll need to talk about sped paperwork days.
Yep.
Yeah, that didn't get good.
And, again, in the interest of time, like, going straight, just not IBB processing this, I can tell you that there would be agreement to continuing that for sure. If that is something that we want to do, it would require putting together an MOU that's just specific to that, because I have to look at the one we did last time. I feel
So
like-
the MOU with the paperwork days also has the 5 of 7 in
Right,
there.
so we don't need to do that anymore, right? We don't need to do the 5 out of 7.
Do we have language for the 5 out of 7 though?
Yeah.
Isn't 5
Yeah.
out
I
of 7
say,
in
I
the
think
contract?
it's not in the contract yet, I don't think. I think I misspoke last time because I thought it was, but then upon further like investigation, I thought it wasn't. I thought it's all just within that one MOU.
Okay, so
So-
how about this? Let me do some homework on that. But just sharing that, you know, again, after Sherry met with us and talked with us, there's interest in continuing it. And then Amber very kindly outlined for me those sub-compensation issues that are, if you look in the agenda for today, outlined in there. And I believe it's been brought up to Dr. Hubbard and she has like committee meetings. Here's what I will tell you, that is a highly complex whole shift to change payroll schedules. It is like health insurance implications, like, there was many bullet points raised for me that like, it would require a lot of work, to do, and I feel like if we want to, now, things like longevity schedule, that's obviously just, you know, do we want to put more money there? But things, and same thing with the instructional rate, but payroll schedule things are things that, again, I will continue doing homework on this. I'm not sure that train can be turned before the start of next school year. It would probably have to be something that we would have to put a work group together that starts working at the beginning of the school year.
That puts a really heavy lift on our payroll department to process payroll.
Like, it might require
Twice a month.
additional staff.
But I think it's
do
something to
that.
look into because of just how things are going and like just the quickness with which a lot of districts can get you your money. So like, well, I don't know, I'm not gonna say that. There are jobs nowadays that you can go get and you're gonna get paid the same day. My husband's getting paid weekly at this point. And then again, having our new to the district staff not get a paycheck until September, but then paying themselves in August, I feel like that's a disservice to them. I don't feel like that's fair.
I think every district in the state of Kansas follows the same thing. Isn't first paycheck always in September?
No. So I'm just saying, doing it that way is not awesome.
No, I mean, I agree. I told Amber, everyone wants to be paid every day. I want to be paid every day. If I can't be paid every day, I want to be paid every week. If I can't be paid every week, I want to be paid twice a month. Everybody wants
Well, and I'm
that.
even okay with keeping the once a month thing, but we need to do we need to at least potentially look into something where we can get that paycheck for August. I mean, for at least the new to the district people.
Jill,
Because
what do you-
that's,
Go ahead.
I just want to share that I brought this up with Hubbard in our monthly meetings, and that's
Okay.
kind of, I think, what you were just talking about. And she talked to Russell Knapp, and he shared that it would not take additional staff members. They could do it. I think he was unsure at that time if it could, how quickly it could be done. So
Yeah.
I think, like you said, doing homework and finding out.
For just that August issue, no, but for a processing payroll twice a month, because we have all these
That's what I asked
different-
about. I asked about twice a month payroll.
Fascinating.
I know, I was surprised too. But
I mean, I
good
would be
surprise.
okay with once a month as long as our new people would also then get paid in August, but I'm also okay with twice a month, so you know.
It
whatever.
sounds like payroll.
I'm
people
okay
need
with
to
all
look
of
and
those
figure
things.
out
We
how
would
to do
need,
it
we
now.
would, like, I can't solve this in this group. We would
Absolutely.
have to
Oh,
put
yeah.
together a
Absolutely.
subcommittee that
That would probably have
includes
to work with
payroll
payroll,
people
Absolutely.
to talk about it. Because I don't think this is like I mean, it would impact the P&A because I think it says monthly, but it's not, it's a logistical finance department issue more than
Right.
Right.
like actual.
I'm just saying it's something that needs to be discussed because it hasn't been discussed, and just with the way that things are going and just how, things work anymore, that needs to happen, so.
No, I mean, I agree.
Or
I
at
don't,
least it needs to be heavily looked into, and if it can't happen, okay, but I think we're not doing the best for our new people if we continue to not look at it and do it the way that we're doing it.
yep.
Okay, so we know what's on the agenda. Someone's probably gonna send an email, put all that.
We also, I do have one more subcommittee that I think has maybe gotten lost a little, but we have the supplemental salary subcommittee.
Under
Oh, yeah.
economics.
So so just a reminder that that subcommittee is ready to share as well.
Okay, so
And the
basically.
budget presentation.
And we have.
Yes, and the budget, that's,
Account.
Right, everything we
question.
just listed out is not the agenda for May 15th, it's the agenda for 15th and 16th.
right, because we have those 2
So
days
there's
back,
a
and we
lot to
have
pack.
10 hours those 2 days? 12?
5 and 5,
Okay,
yeah.
yeah.
5 and 5.
And the calendar question that we have is just having the spring conference day as part
Oh,
of
yeah,
the
you're
written
right.
language.
And I mean, we can talk about that again next meeting. Okay.
Okay, all right, guys, and then I would say next meeting, if we can all, I have to poke around a lot because I try to find old notes, et cetera. Sometimes I have to find them in emails I sent to Jill or Rachel or Amber. But I would say for next meeting, as best we can, let's try to keep our side work closed. So everybody can I want everybody to really lean in, right? Not just 4 or 5 people. Well, 4 or 5 people are great, but we have a team of 10. So let's try to keep side work to a real minimum in the 15th and 16th if we can, because you got a lot to knock out. Any final thoughts? Are we out of here?
Thanks for getting us
Yes,
through.
Started
thank
again.
you.
Thank you.
Huzzah.